I grew up in Hilo and have lived here for most of my life. I've been fortunate to have lived in the Leleiwi area since the 60s. In those days, people didn't want to live along the shore because of the experience of the tsunami of 1960. Our association was created by the same people who convinced the county to purchase the areas that are now Carl Smith and Richardson's Park in 1972. The county and the developers wanted to build a convention center and 5 condos at the end of the road. For 46 years, the parks have been a much loved and used area by locals and visitors. Lately, with the loss of Puna parks, we have seen more and more people, more and more traffic. Another time, in 1982, a developer wanted to build a condominium on a blind curve where many accidents have happened. Our community group convinced the county council to downzone the whole neighborhood as single-family residence. Recently, a developer came to our neighborhood and bought up 5 houses in our residential area. He bought them at a lower price because they were for residences, and then turned them into commercial businesses of short-term rentals. This developer's newest of the 5 houses is a rebuilt 3-story monster house with 6 bedrooms and 6 baths. On his paperwork and on his letters to the neighbors, he called it residential with an Ohana unit. How did this get by the planning department? Now there are price wars whenever a house comes up for sale, at prices locals cannot afford. And out of the 42 houses in our area, 16 are short-term vacation rentals. That's not even counting the short-term vacation rentals in the 3 condominiums in this area. I honestly don't think the planning department is up to the task of malama ka'aina, malama ke kahakai, caring for our precious land and shoreline. They don't have the staff, and they need training. I hear they are getting only 2 people to focus on short-term vacation rentals. That is not enough. I feel they are too lenient on the developers and too strict on the locals. I submitted a email that I got from our lawyer that we had a hearing before the appeals board on Friday, and they basically said there's no entity, there's no provisions for appealing for a small SMA permit. So I hope the county council will get it together and rectify that. So we had a lawyer, Michael Masukawa, who represented us there, even though we hardly have any funds. He spent the whole weekend on his own time reviewing Bill 108, and he had some very good points that I am sending to all the county council members and hope they read it.
There has to be a limit, and it's a hard decision, but certain things are just fair. Limiting people to 1 vacation home, and maybe they have to be a resident of the state. In our neighborhood, we have a man who lives in California and runs 4 vacation homes through his cell phone, not even being here. And yes, he employs lots of people to manage his vacation homes. Nonetheless, I can't get down Oeoe Street anymore because he has 6 cars stacked in his driveway. I'm part of the Board of Appeals. I was approved as an intervener with the Leleiwi Association's appeal of that particular development and how that came to be. This particular landowner did not notify me with the notice requirements on the Ohana permit. I didn't find out about it until less than 6 days before Leleiwi's Board of Appeal hearing. I was shocked. How could he get away with this? I filed my own appeal, and the board gave it back to me and said it wasn't within 30 days of the planning director's decision. I have to go to court now because they won't even process my appeal. I would like to know under the current version of Bill 108, what are the rights of a property owner living less than 300 feet from an applicant for a non-conforming use certificate?
Ms. Roy, you have 30 seconds.
When the applicant fails to serve a notice of the application to said owner, and said owner lives in RS 15 zone, does the council intend that the 30-day statute to appeal to the Board of Appeals is equitably told in those circumstances? Does Hawaii's discovery rule apply? These are legal questions. You have no authority to disenfranchise and not provide due process to those persons living within 300 feet of these illegal businesses. And I say illegal because you haven't provided for any proof that they were lawfully in existence at the time that you're going to pass this amendment.
Hi, I'm Louisa Lee. I'm from the Leleiwi Community Association. I have a property near Claudia. I do want to kind of follow up on the experience that she was talking about with the Board of Appeals. We do have an individual in our neighborhood who operates a number of vacation rentals. One of them sleeps 20 people. It's a new build. There was steps taken to appeal the decision by the planning department to give him a minor SMA, and that Board of Appeals case was recently dismissed. And so through this process, what has become really, really clear to many of us is that there is no clear process for the communities or citizens to appeal developments in their neighborhoods that are inconsistent with zoning laws. Additionally, that there is an inconsistent application of laws by staff or guidelines by staff at the planning department. And additionally, there is debatable advice being given by Corp Counsel to council members about the legality of Bill 108, specifically grandfathering. There is no other county in America that did a 100% grandfathering like this bill is proposing to do. We are strongly for regulation, but we are opposed to Bill 108 because we feel like there still needs to be a lot of work done on the bill. It would essentially, and I've said this in multiple testimonies, but legitimize what we would argue are currently illegal operations. Thank you.
Here's my summary. So all of you people listening in on video and on TV, build whatever you want. There are no resources for enforcing and to limit you. And if you are one who are weighed down by bureaucratic bull, then you may be able to sue for unequal treatment. Thank you very much.